Thank you all for joining us today. I'm Mike Armstrong with the Iowa League of Cities. Um, and we have Jeff Lester here today to um, talk to all of you. I do want to note that there will be CLE available, but we're still waiting to hear the final details from the bar, so that will go out in an email sent after the webinar along with the recording. So with that, Jeff, if you would like to take it away.
Thank you very much. I want to thank the IMAA for inviting me to be here with you all today. It's always great to be talking Iowa municipal law with a bunch of Iowa municipal attorneys. We have a presentation for you today on home rule, and it's supposed to go about an hour. In the past, I've had some criticism and concern about whether I've left enough time for questions, so I've rewritten, updated, and edited this quite a bit to try to get to a appropriate time with questions at the end. But just in case I've edited too much, Assistant City Attorney Gary Guidelock is with me today, and if I run a little short on content, he's going to tell us all about the interplay between historical zoning and home rule authority for the last 10 or 15 minutes of the program. We've got a PowerPoint for you today, and we'll leave it on the PowerPoint for the most part so that people don't have to stare at the light reflecting off my pate, as my children often remind me that they can't see things if I'm around bright lights and don't have a hat on. So I'm sure everyone with a driver's license remembers what it's like to start driving. It's 50 years now, but I vaguely remember learning how to drive. If you're a driver, you've taught people how to drive, or you've had near-death experiences teaching your own children how to drive, or you even know how that works, then you know the basic framework of home rule in Iowa. When you're a driver, you get to decide where and when you want to go, what route you want to take, and what vehicle you want to drive. You're free to make your own choices regarding time, manner, and place of driving, but those choices are always subject to the rules of the road. And the rules of the road allow that control, allow drivers to have independence, but usually only within limits. The rules set those limits and tell the drivers this far, but no farther. Or the rules say, we're going to let you do something, drive a car on your own, go to the grocery store, but this is how you have to do the thing that we're letting you do. You can only go this fast, you can't turn left here, you can't make a U-turn there. Or maybe the rules tell them, you know what, you don't get to do this thing, whatever it may be, in any manner. This road is closed to vehicles. That street doesn't allow through traffic. This street is one way. So instead, it's the controlling rules exclusive function to determine traffic guidelines, and the driver gets no say in the matter. And there you have home rule in Iowa. The state legislature is the rules of the road, setting limits and telling its semi-autonomous drivers, its political subdivisions, driving students, if you will, what to do or not to do in whichever situations that the legislature may choose to provide direction. And the drivers, the political subdivisions, get to exercise autonomy and independence in driving their own affairs unless the rules of the road say otherwise. Now, I'm a big believer in home rule. Why? Because I'm also a big believer in self-governance, decentralization, and local authority to resolve local issues. I've seen the failure of state and federal government in regulating local government and reducing or eliminating potential creative solutions to substantial local problems. To understand where home rule comes from, let's start at the beginning of city government. And no, for all of you poli-sci majors out there, I'm not talking Aristotle or Plato, but the semi-historical beginning of American city government, which, much like our own system of jurisprudence, can be traced to governors granted municipal charters in the name of the crown or the colony's proprietor. These colonial charters often specified the powers of the municipal corporation. After the Revolutionary War, state legislatures supplanted the crown in granting municipal charters. These municipal charters authorized the creation of public corporations as political subdivisions of the state. Eventually, state legislatures had completely claimed the power to create, regulate, and control municipalities. And across the country, for the most part, state control was the key. Our very own Justice John Dillon of the Iowa Supreme Court wrote the leading cases in Iowa, as well as a treatise on municipal law that set forth Dillon's rule. Dillon first sets out the two extremes of legislative authority concerning cities. The legislature can create cities, and as it creates, it can also destroy. And if you imagine a continuum, if the legislature can operate at the extreme ends of that continuum of creation or destruction, Dillon's reasoning provided that it can also do anything in between those two extremes and completely control every aspect of cities' government and city legislation. As the legislature could create, control, or destroy at its whim, Justice Dillon went on to hold that municipal powers were dramatically limited with zero elements of municipal autonomy. A city therefore had only the express powers granted by express words, necessarily implied powers or powers incidental to those express words, and finally, those powers that were absolutely essential and indispensable to the city's objects and purposes. And in searching for those powers, courts were to construe against the existence of the power. So in other words, when city power was in doubt, the courts were to throw that power out. Dillon's rule made for bad government from the local government perspective. Cities couldn't act without express legislative authority. They weren't able to respond to increasing demands for public services from their residents. They had to look long and hard through hundreds of pages of state code for any authority to act on a particular subject matter. If there was no authority, they had to go begging, hat in hand, to the legislature for even the most trivial matters. And this wasn't great for the legislature either, because the legislatures had to frequently spend time on local issues that weren't actually important or relevant to state government, but might have been very important to local government and local officials. The legislature might not act or might not act in a manner that was timely or satisfactory to the municipality, or they might create unnecessarily restrictive or cumbersome processes in order for a city to have the authority that they sought. And lastly, standardized state regulations, many times without necessary funding, known colloquially as unfunded mandates, had a tendency to exhaust the limited financial resources that cities already had. This frustration gave rise to home rule. So what's the philosophy behind home rule? Why does it make better government to have local decisions made by local governments instead of by the state legislature, or worse yet, by no one? I want to emphasize just a few key points for you to consider. Home rule governments and communities enjoy self-governance. There's a decentralization to what they do in the local authority. There is local power and autonomy to resolve local issues. Across the country, home rule has increasingly led the way in adopting innovative social policies in areas like public health, civil rights, and environmental protection. Plus, home rule allows cities to innovate local solutions to fit local needs without involving the state legislature or undesirable statewide limitations. With home rule, municipalities can respond quickly and precisely to change circumstances or emergency situations by implementing legislative solutions at the local level through ordinances rather than waiting for action by the state legislature. This also has the added benefit of precision in drafting legislation, because every concern of what might happen in any given community across the state doesn't have to be addressed. Instead, the local government can focus on its own local operations, its local concerns, its local objectives, and the local results that will be produced by the legislation. Home rule purposes really boil down to three major purposes. Home rule allows for quick, creative solutions to local problems. It enables cities to adopt the kind of government that they desire, and it provides cities with sufficient powers to meet the ever-increasing needs and demands of its residents for local services. On a less pragmatic but still important principled basis, home rule promotes responsive and participatory government by bringing government closer to the people, fostering diversity, creativity, and experimentation by increasing available policy choices. It creates competition for an ever more mobile, ever more transient citizenry across the country. And local government is the most efficient when it's allowed to creatively address local concerns using means suited to local unique circumstances. I mean, who knows a local community and its problems and issues better? The residents and the elected city officials of that community versus the most knowledgeable, well-read, but absentee legislator from a location 250 miles away. As someone who's dealt with home rule and home rule preemption for nearly 35 years, my preference is to have the local elected officials making decisions for their community on local issues. Even the most knowledgeable, well-read legislator from a small rural town of 150 people may not have the knowledge, experience, or frankly, the investment in what goes on in a city like Des Moines of more than 210,000 people. So by empowering local citizens more directly, home rule enhances citizen control, improves citizen interest in the affairs of the local government, makes the citizens more responsive to the government they receive, and most importantly, in my opinion, gets residents more involved in the activities of their municipal government. Home rule is the embodiment of the principle that the best government is the one that is closest to the people. So in Iowa, what do we have? Do we have constitutional home rule or legislative home rule? Well, in 1968, the Iowa Constitution was amended to provide municipal governments the power of limited home rule. The Iowa Home Rule Amendment, found in Article 3, Section 38A of the Iowa Constitution, grants authority to cities to determine their local affairs and government, except for taxing, so long as the authority that's exercised isn't inconsistent with state statutes. Note that the second sentence of the amendment clearly intends to kill Dillon's rule by providing that no express words are needed for cities to exercise their powers. So here we have clearly constitutional, we clearly have constitutional home rule in Iowa. I mean, it's in the Constitution. Certainly that must mean it's superior to legislative enactments, right? Well, not exactly. Even though the Iowa Home Rule is established in the Iowa Constitution, Iowa courts have referred to it as legislative home rule. What does that mean? Well, it means that the state legislature retains unfettered power to prohibit the cities from exercising their police powers, even over matters that were traditionally thought to involve local affairs. And if the exercise of police power over local affairs is not inconsistent with the state statute, with the law of the General Assembly, then the city can act without express legislative approval or authorization. Some have characterized Iowa home rule as a hybrid form of constitutional home rule. It's clearly in the Constitution, but the legislature can preempt the city on anything. There are a number of early home rule cases that we would commend you to look at. Those cases made clear that a city was free to act on matters of local affairs unless there was a statute that expressly prohibited the city's actions. So those cases lean towards express preemption by the legislature, where the legislature seeks to prohibit municipal action in a particular subject area. The courts have held that express preemption offers the highest degree of certainty, coupled with what one court referred to as quote, the added benefit of discouraging unseemly, mutually destructive power struggles between state and local governments, close quote. So we have express preemption then consistent with the idea that any limitation on a city's power over its local affairs are not implied, but they must be imposed by the legislature. So in the Goodell case that's shown on this slide, it concerned a county regulation of hog facilities, and there was statutory language that required express language from the legislature to prohibit local action was not present in that case, but that prior ruling of needing express language was discarded by the Iowa Supreme Court in favor of implied preemption. The dissent in that case rightly pointed out that not only are there no express words from the General Assembly to prohibit the county from the action that it took in that case, there were in fact express words that would authorize the county's exercise of its home rule authority to more stringently regulate that are found in Iowa Code Section 364.3 sub 3. But the majority goes on to find the local government's action preempted. So let's talk about preemption. A quick clarification. One Supreme Court justice described home rule as having the effect that city authorities are no longer frightened by Dylan's ghost. Unfortunately, as we're going to discuss in the presentation this afternoon, the justice was inaccurate because some preemption cases, both in mall realty as well as the overruling of Madden in the Bankers Trust case just this year, show that the haunting by Dylan's ghost continues. Back to preemption. Until Goodell, I would argue that Iowa courts had relatively consistently held that home rule authority was to be limited only by express action of the legislature, even though it narrowly acknowledged but not necessarily regularly utilized implied preemption. After all, the text of Section 38A specifically disclaims any express authority or approval as needed from the legislature. And contemporaneously with the adoption of the Section 38A amendment, the legislature itself specifically noted that express statutory preemption was needed to overrule any home rule action of a municipality. The preemption doctrine dictates that municipalities cannot act if the legislature has directed otherwise. And when the legislature exercises its authority in an area, when it does direct otherwise, then the legislative power trumps the authority of local government to legislate on its own cases, on its own interest. Well, how is this inconsistency between legislative action and that of local authorities determined? In Iowa, it's determined by the courts. So enter the judges. Now, we consider first that we have the text of a written constitutional amendment requiring no express authority or approval from the legislature for a city to take action. We have next 3 specific contemporaneously adopted statutes noting that both express statutory limitations were required to preempt city action and that cities could even go beyond what the legislature had enacted in any given circumstance unless they were, again, there's that word, expressly limited by statute. So this has to mean that preemption must be expressed to be valid in Iowa, right? Well, not exactly. In addition to express preemption, the Iowa Supreme Court also recognizes 2 types of implied preemption. We have implied conflict preemption and implied field preemption, and we'll go through both of those in detail. Despite the legislative direction that only express preemption of local government action was necessary in 364 of the Iowa Code, and despite its own language from earlier cases on the issue, the Iowa Supreme Court decides the matter needs to, quote, ensure maximum loyalty to legislative intent, close quote, in utilizing implied preemption in its various forms. In other words, the court means to discover what the legislature intended as opposed to what the legislature actually said or didn't say. Implied preemption, therefore, arises in two situations where the intent of the legislature to preempt is apparent, even though the legislature did not expressly preempt in unambiguous language. So we have implied conflict preemption. That's our first type of implied preemption. This occurs where an ordinance prohibits an act that's permitted by statute or permits an act that's prohibited by statute. Now, the statute on its face may contain a command or mandate that by its very nature is preemptory. And even though the ordinance may not be expressly preempted, the ordinance cannot exist harmoniously with the state statute when it's diametrically opposed to it. Now, the court stresses that to find implied conflict preemption, the legal standard is demanding. First, there is a presumption of validity to the ordinance. Next, that presumption is overcome only when the ordinance is irreconcilable with state law. Finally, the irreconcilability must be obvious, unavoidable, and not a matter of reasonable debate. But you have to read the Goodell, Mall Realty, and Bankers Trust cases closely to examine whether that really is the standard. All three have a dissent. So can the standard be that it is not a matter of reasonable debate when you have a dissenting opinion in each of these three cases? Or is it just the majority saying that any dissent is per se unreasonable because it's a dissent? This is somewhat like for you municipal practitioners who represent officials or police officers in federal court when we're talking about qualified immunity and the clearly established prong. When you have a three-judge panel and two judges on the panel say that the law is clearly established, but you have a third judge on the panel who says the law is not clearly established. How is a police officer, for example, to know what the clearly established law is when the Eighth Circuit Court of Appeals doesn't know? This is kind of the same thing because the standard is it's not a matter of reasonable debate, but you have in each one of those three cases, you have a dissent. And with the Mall Realty and the Bankers Trust cases, rather than making an effort to avoid irreconcilability, both majorities seem to go out of their way in embracing irreconcilability to get to the result they want, rather than the result that's consistent with the court's 50 years of home rule jurisprudence. But we'll look more at that in a moment. Now, in order for a statute and ordinance to be irreconcilable, the conflict must be unresolvable short of choosing one enactment over the other. So in the Davenport versus Seymour case, the automated traffic enforcement ordinance in that case was held to be supplemental to and not in lieu of the regular Iowa traffic code. This is sort of like the Be Right tire disposal case. The ordinances in those cases, in each of those cases, did not authorize what the legislature had expressly prohibited, nor did they prohibit what the legislature had expressly authorized. Of particular importance in the city of Davenport case was that the court said that there was nothing in the traffic sections of the Iowa Code which addressed the question of whether a municipality may impose civil penalties on owners of vehicles through an automated traffic enforcement regime. In other words, far from preempting the municipal practice, the legislature simply did not address it one way or another. Back to implied conflict preemption. In that case, in the city of Davenport versus Seymour case, which I commend to you as an excellent discussion of home rule authority in Iowa, the Iowa Supreme Court explained that whether a municipal ordinance is in conflict is not determined by the penalties prescribed in the ordinance, but whether the ordinance permits or licenses that which the state prohibits or forbids, or whether the ordinance forbids that which the state statute permits. Now, there really are three key takeaways from Seymour. First, when it comes to home rule, the silence of the legislature is not prohibitory, but permissive. Remember this because the dissent in Madden versus City of Iowa City and the majority in Bankers Trust simply don't understand this principle. When it comes to home rule, the silence of the legislature is not prohibitory, but permissive. So under Seymour, if state law does not authorize the state to enforce its statute through certain remedial options, that does not mean that it forbids cities from using that same course of action. The second takeaway from Seymour is that the real issue in evaluating home rule enactments is not whether the General Assembly has authorized state or local authorities to establish a particular program or activity. Instead, the evaluation is to determine whether state law prohibits municipal authorities from creating such a system, except that Bankers Trust seems to ignore that takeaway as well. Again, keep this quote from the Seymour majority in mind when reviewing the majority opinion in Bankers Trust overruling Madden. Unless the long-deceased Dillon Rule is resurrected, the notion that the mere failure of the legislature to authorize somehow invalidates municipal action is without merit. So cities don't have to have legislative authority to act. Their authority to act comes from the Constitution, except that in Bankers Trust, there was no prohibition on the city action, but the court stood the principle on its head and said there was no authority. The third takeaway from Seymour concerning implied conflict preemption is that state and local regulation may coexist in identical areas, even though local regulation may exact additional requirements or penalties unless the state statute limits those requirements. Again, Bankers Trust ignores that takeaway. Madden affirms Seymour's holding that silence is permissive when it comes to home rule authority, but we have explosive contrary authority to remove momentarily. In a 2015 case I want to look at briefly here, the Supreme Court reaffirmed, thankfully without dissent, the Seymour holding in City of Sioux City versus Jacobsma. In the Sioux City case, the plaintiff argued that the Sioux City ordinance conflicted with Iowa Code sections and was therefore preempted because none of the sections expressly authorized a city to enact an ATE ordinance that imposed civil penalties on registered owners who might not be the actual drivers of the vehicle. The court correctly noted, however, that none of the sections cited by the plaintiff were actually irreconcilable with the ordinance, and that such a finding was required to hold the ordinance preempted. As to the second type of implied preemption in Iowa, implied field preemption, that type of preemption happens when the legislature completely covers a given subject by statute with a demonstrated intent that regulation of the entire field is preempted by state law. Like the supposed standing that's demanding for implied conflict preemption, the standard for implied field preemption is claimed to be stringent. This means that just because there may be extensive regulation of a particular field, that alone is insufficient to preempt the field. Instead, to find field preemption, there must be either one, a clear expression of legislative intent to preempt the field from regulation by local authorities, which I've always found curious. If you have an expression, and especially a clear expression of legislative intent to preempt, isn't that an express preemption? But the court says you have to have a clear expression of legislative intent to find field preemption, so we'll go with that. And to a statement of the legislature's desire to have uniform regulations statewide. So, for example, when the Iowa Liquor Code says that control and regulation of liquor is an exclusive function of the state of Iowa, that's a pretty clear expression of legislative intent to preempt the field from regulation by individual cities. And when in Iowa grocery, the city of Des Moines attempted to put a additional fee on the liquor license application, which we're going to talk about a little more in a minute with the Lime Lounge case, that was held preempted because that fee went to the sale of liquor and the licensing of liquor. And as such, it was preempted because that was an exclusive function of the state. Also, in field preemption analysis, courts are not to speculate on legislative intent, even in a highly regulated field. Instead, there must be persuasive, concrete evidence of an intent to preempt the field in the language that the legislature actually used. The courts caution that they should also not find that the statewide regulation is preferable to local regulation, or that local regulation is preferable to state regulation on any particular subject matter, lest the court be substituting their judgment on policy issues for that of the legislature. But pay close attention to the late Chief Justice's dissent in Mall Realty, as he indicates that the majority risked doing that very thing in the way it interpreted the statute and ordinance at issue there. Instead, courts are to only determine legislative intent actually shown in the words and structure used in drafting the statute. In the interest of time, although we're running just fine on time, I want to turn very quickly to a couple of key home rule cases that are cited in the PowerPoint. Again, the City of Davenport versus Seymour case that we just discussed will be very helpful in understanding home rule preemption under Iowa law. Another key case is the Be Right tire disposal recycling case versus the City of Rhodes. Recall that Be Right is a Court of Appeals case that concerned used tires and the regulation by local authorities of those used tires. In Be Right, the Court of Appeals held, just as the Constitution and Iowa Code 364.3 sub 3 would seem to dictate, that an ordinance which was more restrictive and more stringent than a state statute was a legitimate exercise of home rule power when the legislature had not prohibited the local government from enacting that ordinance. Another excellent case for reviewing home rule principles that I'd like to draw your attention to is the recently decided Lime Lounge LLC versus City of Des Moines case that the City of Des Moines got to litigate for about 7 years. In Lime Lounge, the plaintiffs challenged the use of zoning in evaluating liquor license applications, but the court rejected the challenge. Instead, the court explained that contrary to the Iowa grocery case that I just mentioned, which was decided adversely against the City of Des Moines, in that case, in the Iowa grocery case, the city was preempted from imposing an additional fee directly on the state liquor license application because it was a fee on the liquor license application. In Lime Lounge, the court says the city's conditional use permit fee is not imposed on the state liquor license application. Rather, the city's fee accompanies the conditional use permit application for all applicants, not just those selling alcoholic beverages. It's imposed on all other zoning appeal applications, such as special permits, variances, and exceptions. So the court held that the CUP application fee itself relates to the city's zoning enforcement authority and not to the liquor license application. In other words, it's a fee related to zoning, not liquor licensing, and therefore not preempted. For home rule preemption analysis purposes, the court held that the legislature did not expressly preempt the city's authority to pass ordinances regulating the premises of establishments that were selling alcohol or regulating the zoning of those establishments. Nor did the legislature grant alcohol licensed establishments some kind of special privileges in Chapter 123 to avoid complying with local zoning regulations. And there's also an excellent discussion in that case regarding home rule authority and home rule preemption. If you want to see a difficult and challenging home rule preemption case, however, take a look at Mall Realty versus City of Hamburg. In its analysis of mall real estate, and I use that term very loosely, the Iowa Supreme Court held that live physical nude dancing fit within the state statute preempting local regulation of obscene material, even though absolutely nothing in the statute concerns live physical nude dancing. Instead, the statute is concerned only with printed or other tangible, tactile, physical media. Reading the statute, the legislature defined the term material by listing 5 categories of material containing 21 or more specific items, none of which regulated in any manner live physical nude dancing. In a very pointed dissent for the Iowa Supreme Court, the late Chief Justice Cady excoriated the majority, noting that its analysis and decision defied long accepted rules of statutory construction. He also pointedly noted that the analysis and decision defied common sense. Adding to his criticism, the late Chief Justice called out the majority's use of the absurd results doctrine as itself absurd. And that's a pretty strong slap in the face for an Iowa dissent in the Iowa Supreme Court, but I think the Chief Justice had it right. Finally, the Chief Justice concluded his dissent by noting that the court was running the risk of displacing legislative policy with speculative judicial policy. Again, very strong words, noting that for the majority to conclude it would be absurd for our legislature to have left nude dancing out of its preemption scheme is itself absurd, and that the doctrine must be utilized sparingly due to the risk of displacing legislative policy with judicial policy. In a case decided in 2016, the Madden case involved a City of Iowa City ordinance that imposed liability on an abutting property owner based on the condition of abutting sidewalks and the abutting owner's failure to maintain the sidewalk. The abutting property involved one of the few places in Iowa that I would consider hallowed ground, namely the abutting property was the University of Iowa, and its sidewalks were the sidewalks at issue in that case. Now, in that case, there was already a state statute on the books that created the potential for liability of abutting property owners in certain circumstances. The state argued that the city could not pass an ordinance extending liability to abutting property owners, but the Supreme Court majority in Madden found the ordinance was not in conflict with the statute, as the legislature had not provided otherwise. And remember, the legislature needs to provide otherwise for there to be some kind of implied conflict preemption. Most importantly, the Madden majority reaffirmed that the statute is silent on the city's ability to impose liability on abutting property owners. As it is silent, the court determined that in the context of home rule, legislative silence cannot be interpreted as a prohibition of local action. Now, remember what we said earlier about Dylan's ghost continuing to haunt local officials? Well, if it's not a ghost, the dissent in Madden has now turned into a zombie, as the majority opinion in Bankers Trust. Zombie or a ghost, that is why the haunting of Dylan's ghost continues. The Bankers Trust opinion evidences a critical misunderstanding of Iowa home rule and frankly would push cities back towards Dylan's rule. The majority notes that legislative authorization for imposition of liability exists in one section of the statute. The quote that's provided is that Madden failed to recognize a clear conflict between what the state statute permitted cities to do and what the city attempted to do through its ordinance. The statute permits cities to require abutting landowners to repair sidewalks. Because liability was authorized to be imposed in an accompanying section for a different part of the statute, the court mistakenly concludes that it had to be authorized for this particular statutory duty as well. Therefore, the majority concludes that the legislature did not authorize the imposition of liability elsewhere in the code. But let's put that conclusion in the, well, duh category. That the legislature did not authorize city action is precisely the point of home rule. There is no need to authorize any local action under the Constitution. The authority comes from the Constitution. Bankers Trust misses the point that if the local action is not prohibited, then the city remains free to legislate to its heart's content. If you're afraid of ghosts, then Bankers Trust should keep you up at night. Now, on this particular slide, I want to point out, in particular, the emphasis is applied by me in the quote, but the Bankers Trust authority points to the authority that was granted on a related item as evidence that it was not granted. And it didn't need to be granted. And in particular, I want to note for you the part of the language that says the city's attempt to shift costs to abutting landowners for sidewalk maintenance beyond what the statute allows and to shift liability to abutting property owners for sidewalk accidents beyond what the statute permits run headlong into the legislature's express determination about where such burdens reside. But this is a false premise. First, remember that 50 years of jurisprudence holds that silence is permissive in the context of home rule. The majority ignores this jurisprudence. Second, the allowance and permission needed for authority is in Article 3, Section 38A. It is not in this statute, nor does it need to be. Third, there is no prohibition on cities imposing this liability anywhere in the statute. I've read the statute over and over again. The attorney litigating this for the city of Des Moines read the statute over and over again. There's no prohibition on what the city did. So the ordinance neither permits something that the statute prohibits, nor does it prohibit something that the statute permits. This is what you have to find implied conflict preemption, and it's not there. I also want to point out that contrary to 50 years of the home rule jurisprudence, the Supreme Court now apparently reads silence as prohibitory, at least if the legislature has legislated on any related topic. And lastly, on the opinion itself, I think the dissent correctly points out that the majority opinion ignores stare decisis, potentially violates separation of powers, and the court's words lacks judicial restraint. Those are not my words. My late grandmother, she always told me that if you can't say anything nice, you shouldn't say anything at all. And I have nothing nice to say about the majority opinion in Bankers Trust. So my grandmother would tell me to stop talking. And while I may have the right to remain silent, I do not have the ability to do so. So the second takeaway that I want to point out from the Bankers Trust case is that the court fundamentally misapplies Iowa home rule and makes legislative silence a prohibition, at least when the legislature has legislated on any part of a related topic. So there's that. And of course, the most important takeaway is that they're the Supreme Court and I'm not. So it doesn't matter that they're wrong and the average city attorney can read it correctly. That's the ruling, that's the law in Iowa. This will end the whining baby portion of the program. We've talked a bunch today about the court finding preemption of several local actions, but we need to also remember that in those cases, the rulings are based on the actions of the state legislature. And as we all know, the legislature has been very busy preempting local governments recently, including the ones that we see on this slide. In the last few years, they've preempted city actions to regulate contract sales of real property. They've preempted non-conforming uses and lease purchase agreements. At one point, they preempted city ability to regulate fireworks and the usage of fireworks. Eventually, they relented on that, but then turned around and preempted the city's ability to regulate zoning of fireworks. They preempted scavenger licensing, Section 20 federal housing rental assistance, any requirement now that a city or county tries to place on a landlord to accept that method of payment has been preempted. Building code design is the latest one that's been preempted. So, and I'm sure that there are many more to come because, like many of you around the state, we hear rumors from time to time about this particular activity or that particular activity of the local government that's in need of preemption. So if nothing else, I hope that we can remember three important takeaways for Iowa home rule. The first is no legislative authority is needed for the city to act. And the second is that legislative silence is no longer permissive and might be prohibitory even if the legislature has acted on a related topic. And the third takeaway for today is hopefully it's the Hawkeyes by 3 on Saturday, God willing. I'd like to open it up for any questions. Gary has also volunteered, Assistant City Attorney Gary Guidelock, thank you very much for your help today. Gary has also volunteered to tap dance and play guitar if his zoning questions run short. Do we have any questions?
Acoustic or electric guitar?
Acoustic or electric? I don't have an amp, so it'll have to be acoustic.
Gary said he doesn't have an amp with him, so it would have to be acoustic for today. If Mike, if you want to tell me how you want us to proceed, if you want us to end it at 45, 48 minutes, 49 minutes now, or if you want me to fill, I can certainly do that.
Got some interesting aftermath of that, and I got to represent a party in that case after it came back down. We can talk about that.
Oh, why don't you, Gary, why don't you jump on the mic here and you can share that with everybody. That is actually very interesting.
So one of the after the Madden case came back down from the Supreme Court, the parties found out that it actually wasn't the University of Iowa that was the abutting property owner. They thought that the accident had happened on a sidewalk that was abutting the Finkbein golf course in Iowa City. Somehow it made it all the way up to the Supreme Court without the determination that the accident didn't actually happen on that spot where they thought it was. In fact, it had happened somewhere down the sidewalk, abutting the property of a private homeowner, the former Hawkeye legend, well, I guess he's still a Hawkeye legend, Coach Tom Davis, was the abutting property owner. And so the case proceeded with him as a party to that. So that was an interesting factual tidbit that came down after it went all the way up to the Supreme Court and they made those decisions.
Thank you, Gary. That's very interesting, and that also now makes that ground, almost as unhallowed as if it was in Ames or something.
We have a couple of questions in the Q&A. Are you aware of any pending preemption cases before the state Supreme Court?
Any pending preemption cases?
That's a really good question. I'm not aware of any home rule pending preemption cases, at least not as impactful as Bankers Trust was this year. I can tell you that on the Lime Lounge case, we were quite perplexed because we had, as I indicated, we had been litigating that case for several years. It wound up being over 7 years that the case was litigated. And we had a very solid, decent decision from the district court. We had a very solid, decent decision from the Court of Appeals. And so we were quite perplexed when the Supreme Court took it on further review on the appellant's application for further review, because we thought the case had been litigated well and we had the answer that we needed. And so that one actually made us very nervous. But when the decision came out, it's an excellent decision. And frankly, it's a little confusing to me because the home rule discussion in Lime Lounge is terribly accurate. It's really, really good. And then it's the same group that came up with the Bankers Trust case later. We expected that there was going to be a bit of a problem in that case when it was pushed. The parties wound up settling that case and then took it on to the Supreme Court to challenge our interpleader to bring them in the first place. Because of the ordinance, and we knew that two of the justices were in the dissent in Madden, and that was a concern. But given Lime Lounge, we had felt that there was going to be a majority that would stay there, and they didn't. We have another ATE case that involves home rule, but it's still in the district court stage, so that's not coming before the appellate court anytime soon. That'll be I believe it's a trial later this year, but otherwise I'm not aware of any other ones around the state. I haven't talked with anybody about that.
Is there any chance the Supreme Court would revisit the sidewalk liability case?
Any chance the Supreme Court will revisit sidewalk liability case?
I don't think so at this point. I mean, the problem with the Bankers Trust case is that the legislature, said that. So what happened on that case initially is that the state Supreme Court had reached a decision in, I'm sorry, about that statute. The state Supreme Court had reached a decision about that statute years before, and had held that the people couldn't be forced to clean snow and couldn't be held liable for failure to clean natural accumulations of snow and ice. And the legislature then, after that Supreme Court decision, changed the statute clearly to overrule that decision, to make clear that yes, in fact, that liability could still be imposed. And the Supreme Court then took that to mean that, well, the legislature said that you could impose that liability, and because they didn't go further, that means that cities can't do that. But I think Madden was the one that was correctly decided. But like I said, they're the Supreme Court and I'm not. So Madden was apparently incorrectly decided, and we all have to live with that. I think a much more likely attempt to get that to change is not going to be the Supreme Court revisiting it. I mean, it was a 5-2 decision. I think the much more likely attempt will be some kind of effort, hopefully by the league or maybe the Metro Coalition, to get some kind of legislative change. The reason for that is this impacts every city around the state, and it dramatically shifts at least the last 10 years, but frankly, it's been on the books in the city of Des Moines for a much longer time. So it dramatically shifts the liability and the exposure of cities around the state for people that don't take care of their sidewalks. And remember, the statute does allow the city to require people to take care of sidewalks. That didn't go away. I had a couple of my city council members who were very concerned that cities had lost that authority. That's not the case. What's happened is the ability to shift the city's liability on the sidewalk. That's what's been lost, and hopefully the legislature will give that back. I don't know whether this legislature will be particularly keen on shifting liability from the city to property owners. On the other hand, it would certainly cause cities around the state to speed up their enforcement, and the need to make sure that these sidewalks are kept more in a more travel friendly circumstance, because otherwise the city is going to be facing liability. For example, in the city of Des Moines, it wasn't unusual for us to have a a claim that was filed by somebody that's going to visit mom and dad or going to visit grandma and grandpa, and they fall on the sidewalk in front of the home, and the bringing that person in, bringing the property owner in, once they found out that, oops, grandma and grandpa or grandma and grandpa's insurance company is going to have to pay this claim, that's got a lot of cases to settle more quickly, and in fact got a lot of people not to file claims or not to litigate after they had filed a claim with the city for the sidewalk in the first instance, when we explained that we were going to have to bring in the property owner. That's gone away, and so the city is looking at several options, one of which would be to maybe not increase enforcement, but to expedite enforcement of the sidewalk cases that we have currently.
Great. We have 2 more questions, but we are running close on time. So if anybody does have to leave, just keep an eye out for an email from Mickey Shields or myself with follow-up and information about the CLE. Jeff, do you have any thoughts about the recent restrictions on cladding implemented in 414.1?
Restrictions on cladding in 414.1
Um,
or cladding. I'm sorry.
yeah, I don't really, we're currently looking at that internally. That's in Gary's division to see exactly how that's going to shake out. So but I don't have any independent thoughts about that right now.
Sure. Final question. Are you now operating under the assumption that Iowa is a Dillon's rule state?
Are you operating under the assumption that Iowa is a Dillon's rule state?
No. I think we're operating under the assumption that we've moved back closer to Dillon's rule with this most recent decision. And the idea that silence is always permissive and not prohibitory, I think that's out the window if the legislature has legislated on a related topic. The problem is, where does that relation end? Where does that relationship of the topics end, such that you can safely say that it's a silence on this issue is permissive? So the easy answer would be in an area where the legislature hasn't regulated, hasn't legislated on any aspect of it. I think cities and counties still remain with the authority under Section 38A. I think the problem is going to be, now that the court took an area where the legislature had not said, cities, you can't do this, but they've said that in fact, because we authorize you to do it in one area, the legislature being the we, but because the legislature authorized you to do it in one area and didn't authorize you to do it in another area, that is no longer going to be permissive. That's now going to be, I think it's S expressio inclusius, which is, and then my Latin's horrible, but the idea that if the legislature says this, that here's how you do it, or here's what you can do, then all other areas are excluded. I'm afraid that's where we've gone, and that didn't used to be the law in the state. So I'm afraid that if the legislature's legislated on a particular area or a related area, all other avenues are going to be excluded. We're going to be very, very cautious and judicious in how we look at things, but we have a very progressive council that wants to address circumstances that their residents bring to them. So I'm confident we'll be back in front of the Supreme Court on a new home rule preemption argument case in the not too distant future.
All right. Well, thank you, Jeff. Thank you, Gary. Thank you, everyone, for being here today. Again, keep an eye out for that email. It'll have the video recording and CLE information, but enjoy the rest of your day.
Thank you. Thanks, David.